Hello students, welcome to EPG Pathshala. I am Divya from Delhi University and today we would be discussing about cyber offences under the Information Technology Act 2000 amended in 2008. In the lecture today, we will learn about the Information Technology Act 2000 as amended in 2008. With the help of this lecture, the students will be able to firstly understand the evolution of the Information Technology Act 2000 amended in 2008. Secondly, to understand the significance of framing of cyber laws so as to combat increasing cyber crimes, develop an understanding of the various cyber offences laid down in the IT Act and the punishment and penalties for the same. To examine, interpret and analyze the applicability of the laws relating to cyber offences as laid down in the IT Act 2000 as amended in 2008. Before we move on to specifically discuss the cyber offences as laid down in the IT Act 2000, let us briefly see the evolution and development of the IT Act. It is of great importance for us to understand the need to design and implement a law to regulate the electronic and cyber world. The introduction of the internet has brought tremendous changes in our lives. People of all the fields are increasingly using the computers to create, transmit and store information in the electronic form instead of the traditional papers, documents, etc. With the advent of technology, the world today has shrunk into a microchip and so has everyone's life. Computers, internet and communication have substituted paper-based communication by digital and electronic communication. Information stored in electronic form has many advantages. It is cheaper, easier to store, easier to retrieve and speedier to connect. Though it has many advantages, it has been misused in many people in order to gain for themselves or for the sake to harm others. The high and speedier connectivity to the world from any place has developed many crimes, and these increased offences led to the need of law for protection. Some countries have rather been vigilant and formed some laws governing the act. The United Nations Commission on International Trade Law, that is UNCITRAL, realizing the impetus being given to the computerization, adopted the model law on the e-commerce in 1996. The General Assembly of United Nations passed a resolution in January 1997 inter alia recommending all states in the UN to give favorable consideration to the said model law, which provides for recognition to the electronic records and according to it the same treatment like a paper communication and record. India was also a signatory to this model law and thus it became mandatory for it to review its national law as per the said model law. Therefore, in order to keep at pace with the requirements of the international trading and also to allure industries into adopting this convenient way to transactions and storing data, the Information and Technology Act 2000 was passed by both the Rajya Sabha and the Lok Sabha in May 2000, and the Act was amended again in 2008, which came into force from 27th October 2009. The preamble of the Act quotes, and this is also the objective behind the implementation of the Act, and I quote, an act to provide legal recognition for transactions carried out by means of electronic data, interchange and other means of electronic communication, commonly referred to as electronic commerce or e-commerce, which involve the use of alternatives in paper-based methods of communication and storage of information to facilitate electronic filling of documents with the government agencies, and further to amend the Indian Penal Code, the Indian Evidence Act 1872, the Bankers Books Evidence Act 1891 and the Reserve Bank of India Act 1934, and for matters connected therewith or incidental thereto, Information and Technology Act 2002. Therefore, we can delineate the objectives of the Act into the following major categories vis-a-vis legal recognition to digital and electronic signatures, digital documents, books in electronic modes for bankers. The second objective is to facilitate electronic filling of documents, electronic storage of data. It has also tried to amend the Indian Penal Code, Indian Evidence Act, Reserve Bank of India Act, Bankers Book Evidence Act, and most importantly, to penalize cyber offences and illicit usage of electronic data. Therefore, we see how the rising imperative on the usage of the electronic world to store and disseminate data has led to the implementation of legal statutes around the globe to regulate and improvise the functioning of the cyber world. Next, we move to discuss in short the structure of the Information Technology Act 2002 as amended in 2008. The Act in total has 13 chapters and 90 sections. The Act begins with preliminary and definitions, which are in chapter 2, and from there on the chapters that follow deal with authentication of electronic records, digital signatures, electronic signatures, etc. Elaborate procedures for certifying authorities for digital certificates as for Information Technology Act 2000, and since replaced by electronic signatures in the Information Technology Act amended in 2008, have been spelt out in the Act. The civil offence of data theft and the process of adjudication and appellate procedures have been described. Then the Act goes on to define and describe some of the well-known cyber crimes and lays down the punishments therefore. Then the concept of due diligence, role of intermediaries and some miscellaneous provisions have been dealt with or described in the preceding sections. Rules and procedures mentioned in the Act have also been laid down in the phased manner, with the latest one on the definition of private and sensitive personal data and the role of intermediaries, due diligence, etc. being defined as recently as April 2011. Cyber offences and penalties under the Information Technology Act as amended in 2008. Cyber offences and the unlawful act which are carried in a very sophisticated manner in which either the computer is a tool or target, or we can say both. Cybercrime or offences have not been defined in the Act explicitly, but has been categorized in different sections along with the sanctions and penalizations. However, for understanding cyber offences can be viewed as the unlawful acts which are carried in a very sophisticated manner in which computer plays both the role of it being a tool or a target. Cyber offences are usually generalized into three categories, which are firstly committed against persons, secondly committed against property, and thirdly they are directed towards a state government. Chapter 11 of the Act covers the offences and the penalties that are accrued upon when the law is threatened. Cybercrime usually includes, under its various underpinnings, unauthorized access to computers, data diddling, virus worms attacks, theft of computer systems, hacking, denial of attacks, logic bombs, Trojan attacks, internet time thefts, web jacking, email bombing, salami attacks, physically damaging computer systems. Now we move on to specific cyber offences under the Act. The cyber offences, as mentioned under the Information Technology Act 2000, have been delineated as follows in its various sections. Section 65, tampering with computer source documents. It states any person who knowingly or intentionally conceals, destroys or alters or causes another to conceal, destroy or alter any component, source code used for a computer, computer program, computer system or computer network when the computer source code is required to be kept or maintained by law for the time being in force shall be punished. For the purpose of this section, computer source code means the listing of programs, computer commands, designs and layout and program analysis of computer resource in any form. The object of the section is to protect the intellectual property invested in the computer. It is an attempt to protect the computer source documents or the codes beyond what is available under the copyright law. Section 66, computer related offences. This section, prior to the amendment of the 2008, covered for penalization of hacking of computer system, which now has been elaborated in several subsections. Firstly is section 66A. Section 66A talks of punishment for sending offensive messages through communication service, etc. Any person who, in means of a computer resource or a communication device, sends A. any information that is grossly offensive or has a menacing character, or B. any information which he knows to be false but for the purpose of causing annoyance, inconvenience, danger, obstruction, insult, injury, criminal intimidation, enmity, hatred or ill will persistently by making use of such computer resource or a communication device, or thirdly C. any electronic mail or electronic mail message for the purpose of causing annoyance or inconvenience, or to deceive or to mislead the addressee or recipient about the origin of such message shall be punishable. The communication device means cell phones, personal digital assistants or combination of both or any other device used to communicate, send or transmit any text, video, audio or image. The punishment for such an offence is imprisonment up to 3 years and fine. Next is section 66B, which is punishment for dishonestly receiving stolen computer resource or communication device. This section states any person who dishonestly receives or retains any stolen computer resource or communication device, knowing or having reason to believe the same to be stolen computer resource or communication device shall be punished. The punishment for the offence is imprisonment up to 3 years or fine up to 1 lakh rupees or both. Section 66C, punishment for identity theft. This section deals with any person who fraudulently or dishonestly makes use of the electronic signature, password or any other unique identification feature of any other person. Such person committing identity theft shall be punished with imprisonment up to 3 years. The next section that we deal with is section 66D. Section 66D says punishment for cheating by personation by using computer resource. This section specifies on cheating and impersonation. It says that any person who by means for any communication device or computer resource beats by personating shall be punished with imprisonment up to 3 years and fine up to 1 lakh or both. Next, we move to section 66E, which tells about punishment for violation of privacy. Privacy of any individual goes along with his right to life and identity. Be it breach of any individual's privacy in person or through cyberspace is an offence. Any person who intentionally or knowingly captures, publishes or transmits the image of a private area of any person without his or her consent under circumstances violating the privacy of that person shall be punished. For the purpose of the Act, the term publishes has been defined as reproduction in the printed or electronic form and making it available for public. The punishment for violation of privacy or under the law is imprisonment up to 3 years and fine up to rupees 2 lakh or both. Next section is section 66F. This section talks about one of the worst forms of organized crime, which is now not limited to the traditional crime. Technology has its say in instilling fear. This section speaks of punishment for cyber terrorism. It states a person commits the offence of cyber terrorism if he, firstly, with intent to threaten the unity, integrity, security or sovereignty of India or to strike terror in the people or any section of the people. Secondly, denies or cause the denial of access to any person authorized to access computer resource, or thirdly, attempts to penetrate or access a computer resource without authorization or by exceeding authorized access, or introduces or causes to introduce any computer contaminant and by means of such conduct causes or is likely to cause death or injuries to persons or damage to or destruction of property, or knowing that it is likely to cause damage or destruction of supplies or services essential to the life of the community or adversely affect the critical information infrastructure. Next, cyber terrorism knowingly or intentionally accesses or penetrates a computer resource without authorization or exceeding authorized access, and by means of such conduct obtains access to the information data or computer database that is restricted for reasons of the security of the state or foreign relations, or any restricted information, data or computer database with reasons to in belief that such information, data or computer database so obtained may be used to cause or likely to cause injury to the interests of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement in an offence or the advantage of any foreign nation, group of individuals or otherwise. Whoso is found involved in such an offence is penalized with life imprisonment. Next we move to section 67 of the Information Technology Act 2000. This talks about punishment for publishing or transmitting obscene material in electronic form. This section talks about cyber obscenity in short. It states that any person who publishes or transmits or causes to be published or transmitted in the electronic form any material which is lascivious or appeals to the prescient interest of its effect in each as to tend to deprave and corrupt persons who are likely having regard to all relevant circumstances to read, see or hear the matter contained or embodied in it shall be punished upon first conviction with imprisonment up to 3 years and fine up to rupees 5 lakh, and upon second conviction with imprisonment up to 5 years and fine up to 10 lakhs. Section 67A of the IT Act. This talks of punishment for publishing or transmitting of material containing sexually explicit act etc. in electronic form. This section specifies the form of cyber obscenity and states that any person who publishes or transmits or causes to be published or transmitted in the electronic form any material which contains sexually explicit act or conduct shall be punished again upon first conviction with imprisonment up to 5 years and fine up to rupees 10 lakh, and upon second or subsequent conviction with imprisonment up to 7 years and fine up to rupees 10 lakhs. Next we move to section 67B, which is punishment for publishing or transmitting of material depicting children in sexually explicit act etc. in electronic form. This part of the act speaks of cyber obscenity in relation to children, that is punishment for child pornography. It states that any person who publishes or transmits or causes to be published or transmitted material in any electronic form which depicts children engaged in sexually explicit conduct or creates text or digital images, collects, seeks, borrows, downloads, advertises, promotes, exchanges or distributes material in any electric form depicting children in obscene or indecent or sexually explicit manner, or cultivates, entices or induces children to online relationship with one or more children for and on sexually explicit act or in a manner that may offend a reasonable adult on the computer resource, or facilitates abusing children online, or records in any electronic form own abuse or that of others pertaining in sexually explicit act with children shall be punished upon first conviction with imprisonment up to 5 years and fine up to rupees 10 lakh, and upon second or subsequent conviction with imprisonment up to 7 years and fine up to rupees 10 lakh. However, these provisions does not extend in any book, pamphlet, papers, writings, drawings, paintings, representation or figures in electronic form which is proved in the justified as being for the public good on the ground that such material is in the interest of the science, literature, art or learning or other objects of general concern or public good. Next cyber offence is in section 71, that is penalty for misrepresentation. Misrepresentation of facts and information also accounts for an offence under the IT Act. It says that any person who makes any misrepresentation to or suppresses any material fact of the controller or the certifying authority for obtaining any license or electronic signature certificate shall be punished. The punishment would be imprisonment for a term which may extend up to 2 years or with fine which may extend up to rupees 1 lakh or with both. The next section, that is section 72, talks for penalty for breach of confidentiality and privacy. If any person who in pursuance of any of the powers conferred under this Act, rules and regulations made under the Act has secured access to any electronic record, book, register, correspondence, information, document or other material without the consent of the person concerned and discloses such electronic record, book, register, correspondence, information, document or other material to any other person shall be punished with imprisonment for a term which may extend up to 2 years or with fine which may extend up to rupees 1 lakh or with both. The next section, which tries to deal with cyber offences in the Information Technology Act, is section 72A. Section 72A talks for punishment for disclosure of information in the breach of lawful contract. It states that any person, including an intermediary, who while providing services under the terms of lawful contract has secured access to any material containing personal information about other person with the intent to cause or knowing that he is likely to cause wrongful loss or wrongful gain, discloses without the consent of the particular person concerned or in breach of a lawful contract such material to any other person shall be liable for punishment with imprisonment for a term which may extend up to 3 years and with a fine which may extend up to rupees 5 lakh or may be punished for both. The next section of the Information Technology Act, which talks about the cyber offences, is section 73. Section 73 well and explicitly puts for penalty for publishing electronic signature, certificate false in certain particulars. It states that no person shall publish an electronic signature certificate or otherwise make it available to any other person with the knowledge that firstly, the certifying authority listed in the certificate has not issued it, or secondly, the subscriber listed in the certificate has not accepted it, or thirdly, the certificate has been revoked or suspended unless such publication is for the purpose of verifying an electronic signature created prior to such suspension or provocation. Any person who contravenes above provisions shall be punished with imprisonment for a term which may extend to 2 years or with fine which may extend up to rupees 1 lakh or with both. The next section that in the IT Act deals with the cyber offences is section 74. It talks about publication for fraudulent purpose. It states that any person who knowingly creates, publishes or otherwise makes available an electronic signature certificate for any fraudulent or unlawful purpose shall be punished with imprisonment for a term which may extend up to 2 years or with fine which may extend to rupees 1 lakh or with both. The next section, that is section 75, talks in the Act to apply for offence on contravention committed even outside India. The provisions of this Act shall apply also to any offence or contravention committed outside India by any person irrespective of his nationality. However, for such liability, the act or conduct constituting the offence or contravention should involve a computer system or computer network located in India. This is what briefly describes for what makes for the cyber offences under the Information and Technology Act 2000 as amended in 2008. Next, what we will be seeing is how do we conclude the IT Act. By way of conclusion, what it resonates is the legislation incorporates within its understanding the various cyber offences that the world is under the threat of in the contemporary era. Proper and timely implementation of the Act may help curb the cyber menace and also make the cyberspace a more secure, safe and easy space for storage and functioning and transaction and definitely sharing. Its linkages with other acts like the Indian Evidence Act 1872, the Bankers Books Evidence Act 1891 and the Reserve Bank Act have made it a comprehensive and umbrella act to deal with any kind of cyber offence or cyber crime. Its proper interpretation and implementation is what is the need of the hour, and therefore we all need to work towards to combat cyber offences, and Information and Technology Act 2000 provides us with such an opportunity. Thank you.